Good morning. How are you all doing today? Thank you for having me. I give these talks quite a bit, and I really enjoy these talks. I enjoy talking about this subject. So I am going to invite you, notwithstanding the size of this group, if somebody has a question about something as we're going through things, raise your hand. We'll try and get through it, and then certainly, if you don't want to do that, you feel uncomfortable doing that, find me afterwards. I will be around. Real quick, have you all heard the one about the former cop, the occupational medicine doc, and the attorney that shows up at a Connell insurance company seminar? Now, of course you haven't. HR supervisors have no sense of humor about this stuff. So we're going to talk about comp. I'm going to try and make it enjoyable. Stop me if you have questions. Let's go ahead and get started. A couple things we're going to talk about here is some changes that have been made with the administrative judiciary that's significant. The administrative judiciary is generally appointed by the Division of Workers' Compensation, but it's really appointed by the governor's office, who directs the division to make the appointments. We're going to talk about the commission, why that's significant, what that is, and then some recent comp law changes that I'm sure many of you have heard a little bit about. Fact is I actually wrote the Senate Bill 66, which were the changes that were made in 2016, I believe. Testified a few times on those. I'll give you some background information on how those came about and the significance and so on and so forth. So we might also talk about some recent case law studies if we get to it. So ALJ changes. Really, there hasn't been a whole lot affecting you all down here in the southwest Missouri area. We did have, who's not even up there, Judge Wilson. Tim Wilson retired from the Springfield office about a year ago, and Judge Kevin Elmer replaced him. We've had a bunch of retirements, too, in central Missouri that have been replaced by this administration, one down in southeast Missouri and then one up in northwest Missouri. Generally speaking, I will tell you, I know the first three there. I think they're going to be excellent judges for the system. They all actually know workers' compensation. I will tell you, historically, there's been a real trend of administrative law judges being appointed who don't know the first thing about workers' comp. This is their first foray into the comp system, is being a judge. And, you know, of course, that comes with some problems. But Judge Powell, Judge Farmer, and Judge Patton, I know them all personally, and I know that they do know the subject matter. I will confess, I don't know Judge Asbridge at all, and I haven't been in front of him yet. Judge Baker was a judge in the St. Louis office. He's been appointed to an associate circuit level position in St. Louis, so there's a vacancy. There have been discussions as to who's filling his spot. I don't know if it's been made public or not. So the current commissions. So for those of you who don't know, when you have a contested workers' compensation claim, it of course is eventually tried in front of an administrative law judge. That trial then, the party that felt that they didn't get the relief that they were looking for has the option to request review with the Labor and Industrial Relations Commission. Oftentimes that's referred to as an appeal, and I'll tell you it's simply not an appeal. That is actually a term of significance that has a different connotation than a review. The LIRC reviews these decisions what we call de novo, meaning they don't have to follow what the ALJ did. They don't have to give any deference to the findings of the ALJ. They make their own complete rulings, and they are essentially the jury of the comp system. They decide whether the red light, or I'm sorry, the traffic light was red or green when you went through it. And that's really significant because when the commission makes a factual determination, that can't be disturbed. Much like a jury's factual determination cannot be disturbed except under very limited circumstances, which almost never exist. So how many times have you had a situation where your attorneys sent, or you and your attorneys sent your injured employee to an orthopedic surgeon? The orthopedic surgeon gave his or her opinion as to what needed to be done, didn't need to be done, provided treatment, whatever the case may be. The employee is released at maximum medical improvement. You think, great, let's get this case settled. And then the claimant's attorney sends the claimant out to a nuclear medicine doctor. Not to disparage that specialty, but it certainly is not orthopedics. Okay, nuclear medicine is taking pictures with irradiated dye, I believe, is a fair way of characterizing it. So it's very different than making determinations regarding orthopedics. And then you find out you lost because they believed the claimant's doctor over your board-certified orthopedic surgeon on an issue of orthopedics. Well, a lot of that was coming from our former commission. They were the former chairman was handing down a lot of rulings that frankly weren't very favorable for most people in this room, and they couldn't be touched because it came down to the commission believed the claimant's doctor over the employer's doctor. That's the end of the case. We have a new commissioner. His name is Connell. He's from the St. Louis area. Actually has very little, I would say almost no, workers' compensation experience prior to his appointment to the commission. And frankly, I don't think that's a bad thing. There's been a lot of our system has habits, has tradition that aren't necessarily based on the law. It's just kind of how things have always been done. He doesn't bring any of that with him to the system. So my expectation, and I will tell you what I've been seeing since he's been issuing decisions, is that they're following the law. There also seem to be giving more credibility to the doctor who's actually got a specialty in the questions that are being asked of that doctor. So finally, you'll get some credit, we'll say, for actually sending your employees to the right doctor, and that'll be meaningful with regard to your cases. The employer representative, he's fairly new, Reed Forrester. He's a business owner for over 20 years. He was actually writing some dissents before we got the new chairman that showed that he was having some frustrations with the way these decisions were coming out. And so there was certainly some light at the end of the tunnel we saw until we got the new chairman. And I'll tell you, watching these decisions are published on the labor website, and I click there every day to see if there's a new one. Kind of like with that same level of anticipation of looking up a claimant's Facebook page. Never know what I might find, and it's generally exciting. So the employee representative, he's been on the commission for quite some time now, since I guess 7 years. It's actually a 6-year term, so he could reappoint. Somebody else could be appointed to replace him. Just hasn't been any reason to, I suppose. Okay. So, recent workers' compensation law changes. This is essentially Senate Bill 66. So, have most of you heard that there's been some changes in the drug penalty and how that's applied in Missouri? Hopefully you have. Maybe some of this will be a little bit of a review. And I'll tell you the genesis of this case, or of this change, and why this bill was written. I represent probably represent several of you in here. Maybe some of you know me. Certainly, if you guys are public entities, I know, or I represent the either you or the trust that you're with. Probably, I represented a car dealership trust, the auto dealers. We had a case. I defended it. Claimant had cocaine in his system. It was documented. We had a good drug test. The commission, the old commission, found against us because he determined, or not determined, but the evidence demonstrated that when drug testing is performed, and my friends at Tomo over there can probably tell you all more about this than I can, but generally speaking, with a urine test, you're not testing for the actual substance. Rather, you're testing for inactive metabolites that the body creates from the drug, breaking down the drug process, and then excreted. And so when cocaine is metabolized by the body, it is metabolized into benzo something something that we call BE. And that's what the drug test actually finds. That's what the toxicologist testified to. But he also testified that the individual clearly had cocaine in his system at the time of the accident. Well, the commission said, well, the test was only positive for BE. It wasn't positive for cocaine, irrespective of the fact that that's the industry standard. And said, so there's no real finding of any drugs, and we lost the drug penalty. So, what do you do when you lose? change the rules, right? So I wrote a new bill and decided we're not going to do that anymore. And we actually crammed a bunch of stuff into it, but this is probably the stuff that gets the most headlines is the drug test. So now what we have is this rebuttable presumption, which is legal jargon for it starts in our favor until you prove otherwise. Okay, so we have this rebuttable presumption in conjunction with the way the 2005 changes set up the drug penalty. We had two penalties: 50%, 100%. 50% if the drugs were used in conjunction with the accident, meaning you had drugs in you at the time. 100% penalty if the drugs were the proximate cause. So meteor falls out of the sky while you got cocaine in your system, 50%. You're doing some meth and you drive your car off the road, 100%. Okay, and that's all we were going for in that case was 50%. So the problem was the judges kept, in other cases, not the one that we were dealing with, were having trouble understanding what in conjunction with. I mean, it was really quite silly. We all know what in conjunction with, at or near, same time or place. As I was testifying at one of the, it was either Senate or House hearings, I was explaining to the legislators, I mean, we're in an impossible position here. We know what in conjunction with. The judges keep saying, well, they didn't actually take it while they were getting hurt. You know, I actually said to the legislators, it's almost as if we have to prove the employee got a back injury bending over to do the line of coke, and that's how ridiculous it was getting. So I quickly apologized. I thought maybe I was making a mockery of the system, but that was the frustration I was feeling in this. So we have now given the judges what in conjunction with, and in conjunction with is rebuttable presumption. If there is a positive drug test, and that test is taken within 24 hours of the accident, and we give the employee the results within 14 days, and we give them the opportunity to retest. Now, as you might imagine, my version stopped at positive drug test within 24 hours. There are, of course, competing forces, negotiation going on, and the competing forces got into the bill that the employee has a chance to retest. I mean, and again, the Tomo guys will tell you, false positives really don't happen. We all talk about it. It's out there. I'm not saying it never happens, but the chances of it happening and the incidence with which it happens is, I think, statistically insignificant. But the legislators were extremely concerned about all these poor employees that were going to have these positive meth tests who were really in church. They weren't doing meth, and so that's what got put in, that they get a chance to retest these samples, and that's fine. You know, I expect a retest is going to come back with the exact same result that the first test came back with, but it is important then that, you know, if we don't give them the notice, if the lab doesn't secure the original sample, then that can be a problem. Now understand, all we've done is given a definition of conjunction with. If you don't have a drug test within 24 hours, but a co-employee comes out and says, I saw him hurt his back while he was bending over doing the line of cocaine, you still have evidence of use of the drug in conjunction with the injury. So many people misunderstand, and I've seen advice given that, well, you didn't do a drug test within 24 hours, you can't assert the drug penalty. That's not true. If you do the drug test within 24 hours and you follow these other steps, you've got the penalty until they prove otherwise. You know, and how do they rebut that presumption? I guess they have to testify that sometime between the accident and the drug test, they did a bunch of meth, and that's why they have a positive test. They didn't have it at the time of the accident. So, I'm okay putting them in that position if that's if they want to testify to that. So a couple big takeaways. Keep in mind of the duty to notify, and also make sure the lab you're working with know what their policy is with regard to retention of the sample. And if you didn't, remember, employees have 30 days to notify you of their accident. So if you get notified on day 2, you're out of luck on this 24-hour thing. You can certainly drug test. It may come back positive. You're not going to have the presumption of in conjunction with, but as the defense attorney, I would like to know if the claimant comes back positive for illegal drugs. That tells me something about who I'm dealing with. Where there's smoke, there's fire, often. So, any questions? Let me camp out on that for a second. Anybody need some clarification? Okay. So it's of the injury, and actually, when this was being debated on the Senate floor, I was the team that I was. I'm not a lobbyist. I'm just an attorney. I don't know. Don't get involved in the sausage making much, and so there were some actual professional lobbyists that were dealing there with their whispering into the ears of the legislators, and they were texting me, hey, is this cool? Because they were actually on the floor. There was a suggestion of, well, it ought to be 24 hours of notice. And I was advising, no, please don't do that. Because my concern was if it is 24 hours of notice, so let's say an employee, by the way, the question was, is it 24 hours of injury versus 24 hours of notice? The problem with 24 hours of notice is what happens if an employee on day 24 says, hey, by the way, a couple weeks ago there, or 3 weeks ago, I got hurt, and then you test him within 24 hours and it comes back positive for whatever substance. That clearly doesn't prove to anybody that drug was necessarily consumed in conjunction with the accident. Particularly, any of the drugs that have breakdowns within 2 or 3 days, their detection time in urine is 2 to 3 days for cocaine, and probably similar for methamphetamine. And I was concerned that the courts would simply strike it down, because there wasn't any rational relationship between the two. So it's not the best. There is a flaw with the 24 hours. I have suggested in policies that you make it, if an employee refuses, then that's a forfeiture. So if an employee doesn't take a test, I have wondered, I've never seen it tested, but if your policy says within 24 hours of an accident, you must notify your employer of that accident and submit to a drug test, failure to do so constitutes a refusal. If that's written into the policy, is that going to constitute a refusal? Granted, you have 30 days by law to notify, but still, if you, as the parties have agreed that, hey, if I don't tell you within 24 hours without good reason for delay or something like that, then we agree that I refuse to take the test. I don't know. Any other questions about that? It's also a provision that we put in there that actually I wasn't a part of. Somebody else added this provision. That basically, long and short of it is if we make an offer, they need to accept it or do something with it within the year. And if they don't, then they are bound by that amount that we have offered. And I say offered, the doctor's rating. I don't know. I don't get very excited about this provision. The problem with it is that the employer can waive this. So here's how it's going to break down. On January 1, we give the employee the offer consistent with the doctor's rating of 10% of the elbow. Then nothing happens. Finally, the following year, February 2, so now it's been over a year, gets an attorney. Attorney enters his or her appearance and says, hey, we're willing to settle this case for 15% of the elbow instead of 10, which is, in my estimation, let's say a fair resolution of the claim when it's all said and done. Well, if we can waive, and we know at trial that the judge is very likely to do a 15% instead of a 10%, because this provision only talks about judges approving settlements. It's still whatever the case is worth at trial. So if they're going to drag us out to trial and we know we're going to pay 15% anyhow, well, then let's just pay the 15%, even though they're supposed to take the 10%. That's what the law says, but we're allowed to waive, so we're not going to try this case and end up paying what we know the case is worth after all those expenses. So we'll see how much teeth it has. I honestly haven't had a case yet involving this where I've waived my time-stamped offer at anybody. We'll see. Usually, you know, if they don't have an attorney, usually we can get it done well before the 12 months is up anyhow. Oh, this one. This was kind of my baby, the voluntarily separate. So we all know post-injury misconduct, right? An employee gets hurt, they're receiving treatment, whatever. They tell their boss, by the way, you know, you smell like a skunk, go jump in a lake, I hate you, you get fired. We don't know the employee benefits anymore, temporary benefits, okay? If they are fired for post-injury misconduct, and by the way, they notify you 24 days after the injury, you do the drug test, then it comes back positive, that's post-injury misconduct, okay? You may not get the benefit of 50% reduction, but I would say you definitely have a violation of the drug-free workplace policy, assuming you have one at that point, and I would suggest that a termination of that employee, pursuant to your policy, don't bend the rules because it's comp, but if your policy is you may terminate, and you do, no temporary benefits. But what was happening is employees were quitting. Like, you know what, I'd rather sit at home, watch Family Feud. And we were having situations where we were still being told to pay temporary benefits even though the employer was willing to provide light duty. And I won't get into the details of the various sections and the definitions, but just suffice it to say, there was a strong case to be made in the law, even though tradition has told us if they quit when light duty is available, no TTD. The law wasn't necessarily supporting that. And again, we moved the goalpost and added into the section that if the employee voluntarily separates from the employment while the employer, at a time when the employer was offering light duty consistent with the employee's restrictions, then the employee doesn't get TTD. I mean, this isn't earth-shattering. This just seems like a reasonable result, at least in my estimation. This actually got more kickback from the legislators than any other provision in this bill. They really hated this. And I don't know how many times I heard, well, what happens if the employee is deployed? It was, you know, the veterans were somehow injected into this controversy. And again, I just didn't see how we were getting there. There was this seemingly desire to protect those who would rather stay at home and watch Family Feud. So we got it through though, with really unchanged. So I was quite happy about that. But the key is you can't, when they quit, say, oh yeah, we would have had them straighten paper clips. We do that all the time. You have to be able to demonstrate either you had to have offered light duty, or you have to demonstrate that you always offer light duty or always offer light duty for this type of injury, and you'll be fine. Miscellaneous changes, the hardship hearings, they get them faster just as a reaction to this TTD thing. That was the quid pro quo. The legislators want a quicker opportunity for the claimants to challenge that if they weren't getting temporary benefits. That's fine. Death benefits, they kind of mirrored the death statutes. This really doesn't affect most people, because from the employer standpoint, you're just paying it out. It's really about the claimants and the dependents as to who could receive. So we're going to talk about a couple cases here, and we'll play Was it compensable? See how it goes. So an employee falls from a scaffolding. All right, they found some drugs in the system. THC, we all know that, of course, is marijuana. And a co-employee said he saw him smoking the marijuana. Boy, I sounded like an old person there, didn't I? The marijuana. I believe it was the Mary Jane, I think the kids call it. Co-employee said that he saw the employee smoking pot on the day of. At a temporary hearing, the employee argued that the employer owed temporary benefits. Were the TTD benefits awarded? So, caught smoking pot, co-employee notices it, sees it, testifies as such. Is that a reasonable reason to deny the benefits? The ALJ said, yep, no benefits. Sounds like we got a pretty good case of drugs being used. It was probably the proximate cause. No problem. The commission, old commission, reversed. I told you, they get to decide who's credible. So understand, this judge had a person in front of them testifying. Could see the body language, see whether they're making eye contact, see whether they were really telling a good story, and the judge decided, I believe this witness. Okay? The commission, when they review, all they do is review transcripts. So this commission that had never seen any of the witness, there's no videotaping of our proceedings, just read the evidence. Matt, have you ever used drugs? No. Okay. Matt, have you ever used drugs? No. Transcript looks identical. Two different responses, though, right? So the commission decided that the employee testifying that he saw the co-employee smoking marijuana, they didn't believe him. They decided that his testimony wasn't credible. Ironically, that co-employee testified, but it didn't seem to affect him. You know, he smoked marijuana, but he seemed okay. The commission did believe that part of his testimony. So that's the kind of stuff that you can imagine the frustration that I and others in my position and you all have been experiencing with some of these commission decisions when you're finding out you lost. It's the kind of stuff that we were having to deal with. The 2015 amendments didn't apply, of course, so we didn't have the rebuttable presumption at the time with the positive test. Credibility is key. LIRC, whoever they believe, that's the end of the analysis. They believe Dr. A over Dr. B. Whatever Dr. A says wins. Okay. Oh, this kind of stuff that this one sends chills up my spine. So, employee worked as a truck driver. He files a claim for compensation. That's the initiating pleading that we file in the comp system to get a claim going. The employer didn't file an answer. All right. They didn't even appear at the hearing. Okay, so it was claimant's attorney, and an empty chair. The claimant only had to beat the empty chair. Employee testified that his supervisor told him the employer did not have workers' compensation insurance because they didn't have more than 5 employees. So you remember earlier when the folks from the fraud unit talked about definition of employer, and I assume most of you know that if you are somebody who employs 5 or more employees, then you are required to have comp insurance, but it also means you're within the comp system. If you don't have 5 employees, you're not considered an employer within the comp system, so comp doesn't apply to you. You can't be on the receiving end of a comp claim. So, who won? Wasn't anybody there. Employee's attorney only. How does this one shake out? The employee lost. Okay, the employee lost, and more importantly, the employee's attorney lost to an empty chair. All right. Here's what the commission reasoned is the only evidence in the record with regard to how many employees the employer had was the employee testifying. Supervisor says we don't have 5 employees, we don't need comp insurance. If there is testimony on a material issue that is uncontroverted, then the commission's going to believe that testimony. Even if the commission didn't believe this guy, then there would mean there was no evidence with regard to how many employees, and it is the burden of the employee to prove all facts required to obtain benefits. So it was the employee's burden to affirmatively determine or present evidence that the employer had 5 employees. All that attorney had to do was ask his client, but how many employees did they actually have? And if the employee had said 6, they would have won, okay? Because that would have been, I guarantee the commission would have believed that testimony over this hearsay of the supervisor. So He lost to an empty chair. Lesson, yeah, that's one lesson. You got to prove your case. The other lesson is be careful of an empty chair, I suppose. So, causation. Employee alleges carpal tunnel syndrome due to 30 years of repetitive job duties. Anybody in here work manufacturing, repetitive, get a lot of carpal tunnel claims? Yeah, liars. I know there's some in here. Carpal tunnels, what a mess, right? I've actually tried 4 carpal tunnel cases in the last 3 years. Won 2 of them, lost 2 of them. They can go either way. The ones we won had pretty good medical evidence. The other one I won, their doctor was just terrible. He actually claimed that the carpal tunnel jumped from the one hand where he was doing the repetitive somehow to the other hand, and that's why he had it bilateral, even though. So, employee was diagnosed with diabetes before the carpal tunnel syndrome began. For those of you who have a lot of carpal tunnel cases, you know kind of where we're going here on this. Dr. Schlafly, St. Louis area hand specialist doctor that is traditionally working on behalf of the claimants, was the employee's IME, also performed carpal tunnel releases. Presumably the carpal tunnel must have been denied since Dr. Schlafly was performing the releases. Was the carpal tunnel syndrome compensable? How does this one shake out? Pre-existing condition, the diabetic neuropathy, was determined to be the prevailing factor. So the way carpal tunnel cases shake out is we don't really know what the cause of carpal tunnel syndrome is. Interestingly, Dr. Schlafly, who I've deposed a dozen times, we'll say, and like I said, he always testifies on behalf of the claimants, and he always testifies that it's carpal tunnel related to the repetitive trauma of doing whatever. Now, I usually sit in his waiting room before we start the deposition, and every time I grab one of the little trifold brochures he's got there. So you've got carpal tunnel syndrome, right? These are for his patients. It's got his sticker on it, his name and everything on it. The first line, we don't know what causes carpal tunnel syndrome. That's always Exhibit A in his deposition. You know, doctor, this is yours, right? You don't know what causes carpal tunnel syndrome. Well, I know what it is this time because I'm being paid. So they didn't believe Dr. Schlafly on this case. Generally, I think if we're not if we're not being paid in this case, and we're really talking from a medical standpoint, we have what we call risk factors for carpal tunnel syndrome. They are obesity, age, females, you have a greater tendency to get carpal tunnel syndrome, diabetes, arthritis. Those are probably the big 5 as far as and of course, repetitive trauma is an indicator, but honestly, the studies have shown that's pretty low as far as the risk factors. Those other factors are a much higher risk factor for developing carpal tunnel syndrome. And so the commission finally agreed with those risk factors that that's as likely to be the cause of the carpal tunnel syndrome versus the job duties. And interestingly, and this is fairly common with Dr. Schlafly's opinions, his report always says performs repetitive work. Dr. Schlafly, what type of work does he perform? I don't know. I don't remember. So it's a general statement. The pre-existing risk factors were helpful in that case. Intervening cause. All right. So this is also a fairly recent case. Employee complained eye and throat irritation due to inhalation. It was an exposure to some irritant. Compensable. Nobody disagreed. Employee was being treated by an authorized doctor. While in the waiting room, the doctor accidentally trips the employee. She falls. She injures herself. Now she's got injuries to her knees as a result of being tripped by the doctor. Is this compensable? Are the knees compensable? No, they're not. Not in this case, anyhow. So interestingly, the doctor didn't just accidentally tripped the employee. The truth is, another patient was in the waiting room, had a little yapper dog with her. It was annoying the something out of the doctor. Doctor tried to kick the dog, missed, kicked the employee. She fell over. She hit her knees. So, so I imagine there's other claims surrounding that issue at this point. The comp was the least of her recoveries. So, now this was an intervening event. Now I do want to distinguish this because it makes for a good story and it gets laughs, but I think it is relevant in this case that it wasn't just the doctor accidentally tripped the employee. Because I will tell you, if an employee is receiving physical therapy and that physical therapist gets a little heavy-handed and yanks and hurts something, or some other injury occurs while one is receiving the medical that is a foreseeable consequence of that medical care, a doctor's malpractice. Okay, that is a foreseeable consequence of receiving medical care. Generally speaking, the employer would be on the hook for those additional damages that are caused by that foreseeable consequence of the medical care. As an example, right now we've got a case where the employee injured her knee, and she got some screws put in to put the kneecap back together, I believe it was. You should see these x-rays. It looks like the doctor used like 2.5-inch deck screws. I mean, it protrudes way past the kneecap. You can actually feel it palpated on the skin, the screws poking up and through. Turns out this doctor has been sued and lost malpractice 13 times. Okay, I mean, he really needs to put down the screwdriver. It's terrible, and so the employer had to pay for the additional surgery to get back those screws out, put in the right size screw. It wasn't a whole lot of additional PPD because of it, but there was additional medical costs, and now we're pursuing a medical malpractice case on behalf of the claimant and the employer for subrogation to get the employer paid back, at least for the additional. So, notice the distinction there. The doctor trying to kick a dog was not the provision of medical care, not a natural or expected consequence of receiving medical care, whereas malpractice, as shocking as it may be, is a foreseeable and possible consequence of treatment. Intervening cause 2. I don't remember this one. Hypersensitivity, pneumonitis, a condition, breathing organic dust, compensable, prescribed prednisone. So the prednisone caused diabetes. I don't know the answer because I don't remember the slide, but I bet it is compensable. Yes. Okay. So there you go. There's the distinction that turns out it wasn't the best prescribing the prednisone. Turns out it was the wrong call. Probably, it was medically indicated, but it didn't work out for her, and that was compensable. Synergistic effect. We all know what the term synergy means, or at least have some idea. It's the additional effect greater than the simple sum caused by two effects. The example we have in workers' compensation is the second injury fund. That's all second injury fund is. Okay, second injury fund is supposed to only pay for that additional disability that results from the combination of two injuries. The example that I use most often to try and put this point home is if you have an individual who loses his or her left hand in an industrial accident, that's bad. They have another hand. They're gonna, they'll get through life, but that's certainly troublesome. You have another individual who loses their right hand. Same problem. That's troublesome. But you have somebody who loses both their hands. That person is worse than the problems of the two individuals that each lost one hand. That difference between their combined problem, disability, and the individual got them both, that difference is the synergistic effect. That's what second injury fund is supposed to pay for. That is also, a few years ago, many years ago, it started popping up even when there wasn't second injury fund. So You get an individual who falls from a height, breaks their leg and their elbow. The synergistic effect resulting from both a leg injury and an elbow injury. Basically, it was some good lawyering by the claimant's bar. Gets a 10 to 15% sweetener on cases if they can make the case for it. It was actually tested under the new law whether it still exists, and the court said yes. Injured elbow, had pre-existing knee, so doctor says 15% enhancement. That's pretty typical. I mean, it's with the fiction of the synergy is usually demonstrated by the fact that in every case the synergy is always 15%. So the fact that it's always 15% means that we don't really know. There's no way to truly quantify what that synergistic effect is, so we just assume 15%. So she got the additional 15%. However, the LIRC struck that down, even though it's a typical result. They struck it down because Dr. Poppa didn't explain. He merely stated the conclusion. He just said, no, by the way, the synergistic effect, 15%. Sincerely yours. But he didn't actually dig down into and say, look, here's how these two problems combine to cause a greater disability. So we'll see if how quickly the doctors and the claimant's bar figures that out and gets a little bit more meat to these reports, but it is certainly something we watch for. This is an interesting case. I know there's some public entities in here. This was a public entity case. It was a MODOT case, as a matter of fact, called Mantia. And there is a provision in the statutes that if an employee is subjected to a particular stress of the job and they suffer mental difficulties resulting from that job-related stress, then they can be awarded disability for that mental stress. So what's interesting is this highway worker employee made the case that that she was suffering from PTSD due to seeing all these dead bodies from cleaning up accidents. She was routinely or frequently or at least some amount coming across bad accidents and having to deal with that. I don't for a moment doubt that was probably difficult for her. She was in fact awarded PPD for her mental injuries associated with that. This actually went up to the Supreme Court, and the Supreme Court said no, that doesn't work. In order for an employee to prevail on this mental distress claims, they have to demonstrate that the stress that they experience is greater than what one would expect for other similarly situated employees in their line of work. So, for all of you public entities that have a police force, that's where it comes up a lot. I represent a lot of counties, a lot of municipalities, and the state. So they're involved in a situation. It involves guns out or gunfire or whatever, and so then we get, of course, always get the PTSD claim or allegation along with it. Well, except in really extreme situations, it's kind of what the God bless them. That's what the police sign up for. If you just decide you're going to be a police officer, you put a gun on, you expect that the bad guys potentially have guns, and you expect that at some point you're going to have to use that tool of the trade, or somebody's going to try and use it against you. Now, I'm not saying that no police officer can ever claim PTSD. There's certainly going to be some outlandish cases, but the problem is I was wrestling with a suspect that I was trying to arrest. We fell off the front porch during this tussle, and I suffered a knee injury. Great. We fixed your knee. And by the way, I have PTSD. And I mean, I literally just settled up that case a month and a half ago. Of course, I made the claim that, hey, Mantia, come on. A lot of people don't want to be arrested. And a lot of people, when they don't want to be arrested, see what they can do to avoid being arrested, and that includes wrestling. So there was nothing particularly unusual or stressful about that beyond what a police officer would normally encounter, and we didn't pay for any mental stress. We just paid for the knee in that situation. That's a repeat of what I just told you, I think. Okay. That's the end of my my pitch. I rolled through that fairly fast. I did get the high sign that I probably have about 8 minutes. I am more than happy to talk about, take questions. We've got some, it's Friday, got some great mood lighting. I know you guys want to talk about drugs. Marijuana, I know that's a hot button issue. So I'm happy to talk about medical marijuana. I will warn you, a lot of my response is going to be, I don't know, we'll see. But I have my thoughts on how Justice Matt would rule on such things if it were ever before me. But any questions first? And then I'll... Okay. Well, let me talk a little bit about medical marijuana, what I think is going to happen, how it's going to have to be tackled, and then we'll go from there. So as you know, we passed medical marijuana in Missouri, and the question that keeps coming up is, well, what if they are on marijuana when the accident happens? And I don't know. So there you go. Now marijuana is still illegal at the federal level. States are legalizing it. I suppose it means if the marijuana doesn't cross state lines, then potentially it's not subject to federal criminalization. But the fact is the statutes with regard to the drug penalty provide that an employee is violating the drug-free workplace if they have consumed or have in their body, in their system, whatever, any illegal or non-prescribed controlled substance. All right. Well, we know marijuana is not a controlled substance. It's not FDA approved. Okay. Honestly, I just don't know how doctors can prescribe marijuana other than from a dispensary when it's all a sham on the prescription. So, so I don't know that it qualifies as a controlled substance, whether prescribed or not. Is it illegal in Missouri? Potentially not. It's I mean, just simply if they've got a quote-unquote medical marijuana card from the state of Missouri, I'm going to have a difficult time making the case that they have an illegal substance in their body. Now, there are provisions in the that I've seen circulating with new bills with regard to memorializing and securing the employer's right to continue to make that a substance that they don't want at their workplace, and how that's going to interact with these laws. We'll just have to see what the language looks like. We still do have drug policies, and we still do have misconduct. I will tell you though, every time I got a case referred to me and the adjuster said, and we got a positive test for marijuana, the adjuster was generally more excited than I was. Okay, many of you know that marijuana is metabolized by the body different than the other drugs. The marijuana is metabolized through the lipid system and the fat cells. It sticks around for a long time. Most of your others, the body works on them over 24 to 72 hours or something like that, and you've gotten most of it out of you. And I'll defer to the guys in the back on details of that. But so certainly before we had the new change, a positive drug or a positive THC test didn't really excite me because it didn't really demonstrate that the employee had taken it at or near or in conjunction with. Also, mores have changed. So if I get a drug test the following day, 12 hours after an accident, and it comes back positive for THC, remember, it's just a rebuttable presumption. The employee can present evidence that rebuts the presumption that the drugs were consumed in conjunction with the accident. So they can say, yeah, I smoked some marijuana last night. Nobody's going to lose their mind. Nobody's going to light their hair on fire. People don't seem to care that much if someone's smoking marijuana at home on their off time. So I don't think employees are going to be particularly concerned about testifying that they were doing that on their free time, which would rebut the presumption that they had it in their system. Now, depending on the testing, one may be able to determine when the marijuana was smoked based on certain levels. I don't think that could be done with urine, but potentially with blood, because then you're actually testing for THC. So, you know, all I'm going to do is I'm going to hit home the point that we're going to have to see until there's some actual cases that come out on this. I would still, if I am an employer, I still think marijuana is an illegal substance in the state of Missouri. It is still on my drug-free workplace policy. I don't want my employees showing up with marijuana in their system, and I don't self-insure. I don't make my own decisions with regard to workers' compensation. We have comp insurance like everybody else. What my comp insurance carrier does, if one of my employees has THC in their system, you know, it's between them and the employee. It's you know, we'll see. And yeah, but Matt, there's medical marijuana everywhere else. What do they do? That's the problem with trying to borrow from other states. You know, what do they do to answer the question? Workers' compensation is what we call a creature of statute. It didn't exist there was no ye olde workers' compensation system brought over from Great Britain. So it was created during the Industrial Revolution, and every state, there is no federal workers' compensation system. Well, there is for federal employees, but there's no nationwide comp system for your employees. So what comp looks like in Missouri is completely different than what comp looks like in Arkansas, what it looks like in Kansas, Oklahoma, Illinois, you name it. So, so what they do in Colorado and how it affects their comp system, they don't have the same drug penalty statute that we have. So there's no way to apply what we may have learned from those other states to Missouri. There's no other state that has our drug penalty. So there's no way to know those things. So we'll have to see. There will be, no doubt, a wealth of litigation. God bless America to decide that. So we'll see. We'll see. Any questions though that I can try and answer specifics on that? There's one way in the back. Go ahead. I'll try and hear you, and I'll repeat it. So the question is I work near the Missouri-Arkansas border. I have a lot of employees that are both in Arkansas and Missouri. Which law applies? It's a great question, which, by the way, is code for that's a really hard question. Generally speaking, where the contract of the employment was created is the controlling law. So I do have several cases involving injuries that occurred in other states, but that's because they're trucking companies. All right, so or they were providing a delivery. So just because the accident happened in some other state, that doesn't mean that's the situs of the venue for the action. It's generally where the employment contract became final. So you send an offer from one state, it's received in another and accepted. Now you've got an employment. It's where it was accepted. But then there's all the exceptions to that. So and other states may have different laws, and they say, well, anything that happens in the accidents that happen within our borders, we handle as comp. So then I've had numerous cases where, well, they already settled up their North Carolina case, and fortunately they just dismissed their Missouri case. We didn't have to battle as to whether or not we got a credit for that, which certainly we would have.
All right, thank you, Matt. Let's give him a round of applause.